Hello again, Anita.
Hi, we're
So
back.
we are back and we are here to continue a little bit about the phase before we get into the initial hearing. We did speak previously about a few things. I just wanted to follow up on that, and that is the pre-hearing conference. This is something that is unique that we have before the initial hearing. So tell us a bit more about that and how important it is it, if it is important
Right.
at all?
In our other segment, did touch on the fact that I think sometimes these pre-hearing conferences are a bit of a ruse, and they are used. Um, they don't center your client or your client's interest in getting a first disposition. They center the review board's sort of work volume in not being able to accommodate a hearing within 45 days. You have to appreciate that the ORB now holds all their hearings in person with rare exceptions for Zoom access in a certain kind of hearing only restriction of liberty reviews. We can talk about those later. But the default mode of hearing is in person at the local hospital. And these schedules are put out like a year in advance. It's very difficult to find a hole to get an initial hearing scheduled within 45 days. And so the review board considers the hearing underway when they just schedule a phone call with the Crown Attorney, the hospital's lawyer, one of the review board alternate chairs, so usually a retired judge or a lawyer who's been practicing for more than 10 years, chairing this pre-hearing conference. It's to allow the board to suggest that it met the statutory deadline, even though it's clear they've not. And it's to allow the hospital's lawyer to seek an order for a mental status assessment or risk assessment of your client so that their psychiatrist can get paid extra to do that assessment. They don't serve your client particularly at all. And so my practice is to try and agitate that in some circumstances, it's not necessary to have an assessment at all. There will be a recent assessment of some sort that, makes some kind of comment. Or if the person's already in hospital, they've got an attending psychiatrist who knows them, has access to their charts. But sometimes you have no choice, and then you just want to get the hearing date booked as quickly as possible. So there are a few reasons for that. If your client is in a hospital, still from an assessment stage, for example, before their initial hearing, they will not have any privileges off the ward at all because they cannot get any privileges until such time as the board renders their first disposition. So it's actually very important, even for a client who you're expecting will get a detention order, to have that first hearing happen so that they can have a first disposition order issued by the board because they're under the board's jurisdiction, but the hospital they do not have the authority to give the person a pass, even with staff of the unit, unless there's a disposition that allows for that type of pass. So it is very important to have an initial hearing as soon as possible. So what you are doing at these pre-hearing conferences is trying to secure the first available hearing date instead of trying to get more and more pre-hearings going. Sorry, that's a landline ringing. There's nothing I can do about it because I can't even find the phone. So we'll just have to deal with hearing it and see what happens next. Sorry about that. That's always fun when you're doing live recording. So that's what you're doing. You're on the call trying to get a date as quickly as possible for that hearing. Unless, sorry, I feel like my clients. Well, I think I hear something. Unless you're not. Unless what you're doing there is perfectly happy to go along for the ride with long delays, and maybe contributing to those delays. Uh, in a case where, for example, if it's one of those cases where your client's been out on bail for many years and they are well ensconced in the community and they're fully reintegrated and they're living with a parent or they're living on their own or they're working, they have, a partner, job, and everything is fine, but you're concerned that some assessment will result in an initial
Hmm.
detention order.
Yeah,
And the longer they're out there doing well, the more evidence you have to support keeping them out
right.
there for conditional discharge. So it all depends. You have to sort of think about it a little bit. We've got a lot of things going on. So in the meantime, though, like what can you do to prepare for these pre-hearing conferences? So the initial hearing documents package that comes in before an initial hearing will often be relatively large. As I said, they'll have transcripts in it, it'll have assessment reports in it, the NCR hearing, submissions, underlying records. And so you want to read all that before you even get to a hearing. You wanted to talk a little bit about legal aid. This is a problem period in terms of your ability to get paid. Legal aid, their practice, at least in Toronto or however they do it, they won't issue us a certificate to our office to represent someone at a review board hearing unless there is a notice of hearing for a hearing with our name on it as defense counsel. And you see, we don't get a notice of hearing until
Hmm.
there is a hearing date set. So all these pre-hearings are not hearings, and we don't get notices with our names on it that we can say to legal aid, here's the hearing date, and so we need a certificate. So,
And sorry, just to clarify here for those who are not very familiar with that,
yeah,
if you are representing a client on a criminal
yeah,
case before the NCR finding, you're representing them on legal aid. That certificate is valid until that NCR finding that last day in criminal court. But once the client gets transferred into the ORB jurisdiction, you need a completely different certificate. And you also, with legal aid, you have to be on the ORB
panel.
roster or panel. So you have to make sure that, first of all, you're able to take on ORB cases with legal aid, and you have to make sure that you get that second certificate. So don't make the mistake that I made with my first case, where I just assumed that I could still represent my client under the ORB hearing with the criminal certificate. I didn't know at the time that I needed a completely new certificate to be issued. So this is something that just a practical tip to lawyers who don't know about this.
Yeah, yeah. And, the file will come to you, and the default position of the review board is that trial counsel will appear at the first disposition hearing, and so you'll get the information about that. If you don't want to practice in this area, you don't want to follow your client through to the initial hearing, then it's important at the first available opportunity to make that referral to a specialist or to someone who's comfortable to take it on a quick turnaround, because it might be a quick turnaround depending on where your client's at and what's going on. So, you do also want to know like who are the lawyers locally in your area who are expert in this area. And you maybe want to go down. If you do want to learn about how to do these hearings well, they are open to the public. You can go down to the hearing room at the local hospital, whether it's in Ottawa or Kingston or Thunder Bay, North Bay, St. Thomas or Toronto, Oshawa, Hamilton. You can go into the hospitals and ask where the hearing room is, call the review board, ask what days they're sitting, and they are in person. You can go in person. There are, like I say, some on Zoom. You can also ask the review board to give you a Zoom link to observe some of those hearings that are on Zoom. And I really encourage you to do that. When I first got into this area of specialization was circa 1997. I think I came to the review board work a little bit after, maybe even much after I started doing the civil consent and capacity board hearing. And the way I learned was I went down to CAMH here locally in downtown Toronto, and I went into the hearing rooms and I watched my colleagues who I knew would do a good job.
All right. So, is there anything else that lawyers need to be mindful of at this stage, just before we get into the?
Yeah, so it's hard. Won't get a legal aid certificate unless you have a notice of hearing. The practice is here. So you want to push for a notice of hearing, set a hearing date so you can get legal aid authority, because you're going to end up paying, for example, disbursements costs associated with health records. So you're going to get some information from the court, but you need to, if your client is in the hospital, you need to get their hospital charts and records as well to see what's happening with them in the hospital, because maybe they're doing great. And I guess the last thing I'll say on this is the initial disposition is extremely important. So there is no more important hearing in the review board process than the very first hearing, because It will be the benchmark against which subsequent hearings are measured. So if your client starts off with a conditional discharge, then perhaps next year they get an absolute discharge. But if your client gets detained, a detention order is in hospital, they may get stuck there for the next 5 years before they get re-released again. So you want to aim for the most liberal possible disposition at the outset, and that will make a big difference or could make a huge difference of, to the tune of years in terms of before your client gets out. So that is a very important hearing. You want to learn as much as you can about your client. You want to talk to the client, you want to talk to their family. You want to be able to, at these pre-hearings, say, well, we're likely to seek a discharge, and we have a lot of people who support that position. So it's also a bit of a, case management conference. It's a bit about narrowing the issues. If you know where you're going with something, sometimes I know very early on that the hospital is going to recommend detention because they haven't bothered checking how this person's doing in the community. But I know that I'll be able to show that they should stay in the community, and I'll be building that case and I'll tell them that. So yeah.
And one thing that I also wanted to mention, this is also a practical tip, is that the information or communication and documents that you'll be receiving will be on a special portal. It's not the disclosure hub that we have in criminal law. It's very different. It's you will be notified, because if you are still going to be the same lawyer who's going to be following the client into the ORB, you'll receive an email, and it will be on a different portal where all the information relating to that case will be found. So just to let people know in advance that really everything is different here, like the
It,
communication.
no, it's a different world. And once we start talking about how the hearings proceed, I think you'll see that the rules of evidence that you're used to being commonplace of the review board don't, sorry, in courtrooms, don't apply at all.
Yeah.
They are very much looser, and that is most often to your client's disadvantage. So one of the things you want to learn is how to use it to your advantage, how to get away with filing things that you would never get away with filing in a courtroom. But it does work against you. You get all kinds of hearsay. You get expert testimony and opinions that goes well beyond what you would normally hear it, and you get all that expert testimony without a voir dire as to qualifications. It's just taken for granted that whoever is showing up is an expert. And we can get into all that next time when we've had a chance to change our clothes. So it's a good new day.
Thank you so much, Anita. And
Thank
so
you.
we'll talk soon again.
We will. Thank you so much.
Thank
See
you.
you next time.
Yes.